Coming at you today with a bite-sized episode. I want to highlight a recent conference I attended, HRSouthwest in Fort Worth, Texas. Honestly, it has become one of my favorite annual conferences to attend. This year, I spoke on corporate immigration benchmarking best practices. So a lot of the surveys from the Immigration Benchmarking Collective, I was able to share with attendees to that conference. I love this conference not only to visit friends and neighbors. I used to live in Dallas, so it's fun to check in on old friends and neighbors, but also to hear what's going on in the HR space. The sessions were excellent. Heard a lot about risk management, HR compliance, labor and employment issues. There are a number of different sessions and educational tracks within the conference, and I focused a lot on the employment law and labor relations educational tracks. That being said, these sessions were led by excellent speakers with a very engaged audience. I think the session size was really great to involve audience questions, a lot of participation, a lot of learning. I also got to cuddle a cow in Cowtown. So overall, an excellent experience. Some of the sessions I really liked were about the state of the non-compete agreements, which has been confusing in the employment law space. So we got to hear a little bit about that. And what I really want to dig into is in that session, the labor employment attorney was describing also the state of pay or stay provisions. And in the immigration mobility space, especially in U.S. green card sponsorship, we call those clawback agreements. So there have been some updates and changes and advisory from the National Labor Relations Board. So I wanted to cover those briefly because it does impact the immigration space. What does pay or stay have to do with the practice of immigration law? Well, it comes up in these clawback agreements that I know many of my clients have in place before starting the green card sponsorship. And in fact, in our recent green card sponsorship survey, we found that about a third use these stay or pay or clawback provisions for green card sponsorship. So meaning before the company starts the green card sponsorship, they require the foreign national employee to sign this type of agreement, meaning the company will pay for the green card. And if the employee leaves before a certain agreed upon timeframe, the employee must repay certain parts of the process back to the company. And of those companies that require the clawback agreement, almost all are enforcing it. And I think this is relevant to hear about the updates of pay or stay agreements to make sure they are compliant with federal employment guidance, as well as your state's specific employment requirements. So that's all to say that the state of the stay or pay provisions at the federal level has been updated. So recently, the General Counsel of the National Labor Relations Board put out an advisory statement saying that most of stay or pay provisions will be considered presumptively unlawful. So a lot of legal terms in there, but to unpack it a little bit, the GC of the NLRB said that if the stay or pay provision is narrowly tailored, then the stay or pay or clawback agreement could be enforced and lawful. The criteria that the General Counsel outlined is that the stay or pay provision must be optional, offered in exchange for a benefit, contains reasonable and specific repayment amount and stay period, and finally, forgoes payment if the employee is terminated without cause. So again, more legal jargon to define whether your stay or pay agreement can be considered lawful if enforced. So my takeaway from this is if you are enforcing stay or pay provisions, clawback agreements for your green card sponsorship program, you want to have it reviewed by your state certified employment counsel. You also want to make sure you're reviewing it with your immigration counsel because not all immigration processes, legal fees, government filing fees, can be paid by the employee. So you can't require a full repayment of all immigration processes in a stay or pay agreement, even if the stay or pay agreement is legal under state employment law. It may not be legally enforceable under federal immigration law. So there's sort of two standards of review you want to make sure you're clearing through Immigration Counsel to make sure you're enforcing payment of legally permissible fees for the foreign national employee. And then you want to make sure that the Employment Council is reviewing it for any state regulations to enforce a stay or pay agreement and under this recent guidance from the NLRB. Now, not all companies are subject to review under the NLRB, but it is a best practice to understand where the state of federal employment law is, to understand whether you're complying and, what risk tolerance you have. So these are great questions for end of year housekeeping with your Immigration Counsel and Employment Counsel. That's it for today. Thanks for joining me on the Business Immigration Benchmark.